Thank you very much, Raphael, for that introduction, and thank you very much to all the hosts here, especially Professor Alfonso, who has me back for a second year, and I'm very pleased to be here and to have the opportunity to speak. So I'm presenting a chapter that I've written with my co-author, Iain MacNeil. As you can see there, the elusive purpose of corporate purpose. So corporate purpose has emerged as a key focal point in the debate on how corporate governance might contribute to sustainability. In earlier research, we proposed an entity model of ESG, environmental, social, and governance considerations, which encompassed the role of corporate purpose in the transition to sustainability. While corporate purpose was referenced in that model, it wasn't the main focus of attention, and so in this piece we elaborate on the potential of corporate purpose to contribute to sustainability, with a particular focus on UK law and practice while referencing developments in the EU and at the global level. So in today's presentation, I'm going to focus on the meaning and definition of corporate purpose, who should be responsible for its implementation, and how it should be done. And I start by distinguishing three different contexts in which corporate purpose has played a foundational role in the framing of the law. And then I move on to examine the contemporary debate around corporate purpose and how proposals have developed that would change the role of corporate purpose. So, like I said, and this piece today links with earlier research, and I'm not going to go into details on that earlier research, but one of the key aspects of what we term the so-called ESG entity model was that the contemporary focus on ESG might move from being what we termed a financial model, financialized model, which is moderated and the responsibility mainly of investors rather than companies, that we would move from that financialized model to an entity model whereby enterprises, and particularly their boards of directors, would have a more important role in making decisions around the transition to sustainability. And one of the key elements of that model was that there should be more effective internalization of externalities. In other words, that the costs of issues like environmental degradation should be taken on board by companies, and that the governance structure of companies should adapt to make those decisions possible. So, moving on to the meaning of corporate purpose. In the paper, we focus on three different contexts where corporate purpose has been an important element of the law. And I think this would be evident in many jurisdictions. Firstly, in terms of entity selection, purpose is important in distinguishing between different types of entity. So, for example, partnerships, which in some systems have including the UK, have a purely commercial focus, and at the other end of the spectrum, charities with an exclusively public benefit focus. And in between those, there's an increasing range of options. So at the global level, for example, we could point to the emergence of B corporation certification as a model which focuses on the transition to sustainability. Now, when focusing on this concept of corporate purpose, there are two broad approaches that are adopted by commentators. And I term these direct or indirect adjustment of purpose. Direct adjustment would, for example, be the amendment in the Articles of Association of any provision that relates to the purpose of the company. And that's one option which has been proposed by some commentators. The other would be to focus on a more indirect approach, whereby the variables that contribute to purpose or are capable of adjusting purpose are the main focus of attention. And those variables would include profit, capital, and the mode of operation of the board of directors and the capability of the board of directors. So I mentioned some of the ideas here already, but perhaps the second one is the key element in a quick review of this. So, corporate purpose and entity selection are linked to the founder's vision for how the business will operate and how it will balance the interests of shareholders and other stakeholders. And that's really the issue that I'm focusing most on today. How could corporate purpose as a legal concept be adjusted to more effectively integrate stakeholder interests into corporate governance and deal with the issue that I identified, the internalization of externalities, which is one of the key issues in the transition to sustainability. I'm going to pass over this one because it really belongs to a longer presentation. So, focusing, as I said, particularly on the stakeholder protection dimension, we could reference a couple of leading definitions of corporate purpose to give this discussion a bit of context. And you can see the first there from one of the prominent players and one of the prominent companies in asset management and therefore also in corporate governance, Larry Fink from BlackRock, giving us this definition back in 2019. A little bit dated now, but certainly still carries salience for what BlackRock and many other asset managers have been doing in recent years. So there you see the idea of corporate purpose is a higher purpose that goes beyond the sole profit orientation. And this is one of the key aspects. To what extent would the profit orientation be adjusted to provide for more to provide for a better transition to sustainable companies? The second definition is a little bit more cryptic, I think, personally, because it's focusing both on positives and negatives. This is from a very influential study carried out by a team appointed by the British Academy called the Future of the Corporation Project in the UK. So it's recognizing the central role of profit in purpose, as I mentioned, but also focusing on eliminating some of the negative aspects that would typically be linked with pursuing profit. The second view, and I'm going to pass over it fairly briefly, we call it a view from the courts, is really just referencing the support that has been given by the courts in the UK to what we tend to refer to as the shareholder primacy model, which is embedded in UK corporate law, and actually you could say embedded in many systems. So the case, I think in the third bullet you can see there, the common law approach of shareholder primacy is carried forward into the 2006 Act, which is the main corporate governance provision in the UK. So, shareholder primacy, as you know, is the idea that when boards of directors are balancing interests and making decisions, they would give priority to the interests of shareholders, and by doing that, they would tend to focus on profit as the primary objective, if there were some balancing required with other matters, such as the transition to sustainability. So then we move on to the diagnosis of the problem. In other words, what is the problem with corporate purpose? Now, there have been various approaches to this. There's been the British Academy. There's been Paul Davies, who's a professor at Oxford. There's been Alex Edmonds, who's published a very influential book called Grow the Pie. And all these studies have focused on some specific problems that arise in the corporate governance system. Now, Davies has a more evolutionary approach to the whole problem. Edmonds is probably more transformational, as is the British Academy. And I think to understand how they have diagnosed the problem, probably the more concise way is to think about the solutions or the proposals that they have developed around purpose. So we could say that the British Academy approach is transformational. They're not looking for evolutionary change. They are proposing substantial changes to purpose, and particularly focusing on the need to value and report on human, social, and natural capital. So, one of their arguments is that the process of valuation and reporting is instrumental in the way that boards of directors make decisions. And so they're proposing that as well as enterprise costs, that social valuation should be incorporated into reporting, thereby encompassing negative externalities and positive externalities in the financial reporting that is carried out by companies. So I'm not really going to go into the others in much detail, nor am I going to say much about linking purpose back to the entity model that we had proposed before. I think the key dimension really, and I'm going to flick through to, so here, and you could look at this later, here we specified by reference to the earlier entity model how corporate purpose could play a role. And I think essentially our approach to this problem would be to say that an evolutionary approach would be the best, that actually making use of the discretionary powers of boards of directors to make decisions which favour a transition to sustainability is possible in many legal systems, including the UK, and that therefore a substantial change to corporate purpose can be driven by the board already. In other words, under this evolutionary approach, the board is empowered and capable to make the necessary adjustments and should be encouraged to go ahead and do that. So I think in summary, the second point, there's been a lot of attention on sustainability and stakeholder protection recently. The emergence of the debate on corporate purpose draws attention to the need to adjust board decision making rather than just relying on the more indirect effects which are currently transmitted through the financial investor channel. And so by conclusion, what we argued in this paper is that adjusting the levers of purpose, particularly profit, capital, and board decision making, rather than trying to adjust purpose itself, may be a more realistic solution, because trying to jump immediately to the transformational approach of adjusting purpose directly may be a step too far. Thank you.